All right. Can you hear me, Nick?
Yeah, I can hear you.
Awesome. Awesome.
Perfect.
Awesome. Great. 1 second. I think the slides just went off the screen. Can you still see the slides, Nick?
I can't. Okay, there it is. I used to just put it up there.
Great.
Perfect.
Yep. Awesome. Thanks everyone for your patience. Was just getting up and running. I wasn't able to get it up and running on my laptop, so just gonna go right off my phone. Sometimes the phone can be even more convenient than the laptop, and that is the case here. But I'm here now, and that's all that matters. So Nick, great to see you. Thanks for being here. And for everyone that is joining, welcome to the webinar that is being hosted by Flippa and Optimist Legal. We are here to talk about how to sell your business for the most money. And specifically what we're going to be focusing on is how founders can increase exit multiples, create buyer confidence, and avoid legal mistakes. So essentially, we want you to make the most money possible. That is why both Nick and I are here. That's what we hope you get from the webinar today. And again, my name's Omid, and I'm here with Nick. Nick, why don't we start off by just telling you, the audience, a little bit about yourself?
Yeah. Welcome, everybody. My name is Nick Carlucci. I'm a business broker at Flippa. I help entrepreneurs sell their business. I've been in the business for a few years and have been a part of over 100 exits. So I look forward to sharing some insights from my time in this space with all of you to help you achieve a similar result, hopefully in the near future.
Awesome. Thanks for the intro, Nick. And on my side, my name's Omid, and I'm the managing partner at Optimist Legal. Optimist Legal is a corporate boutique law firm, which means that we are lawyers that help founders sell their businesses. We're also corporate lawyers, so we do any sort of work in the contract space. I've got 10 years of experience both scaling businesses and selling technology companies. So it's a real pleasure to be here. And just some housekeeping items. As we go through the presentation, please do drop your questions into the chat. As they come up, we want to make sure your questions get addressed. But we're going to be taking all of the questions at the end of the presentation just to make sure that we have enough time to get through all the content here. And we're going to reserve more than enough time at the end of the presentation for any Q&A. Just make sure you drop it into the chat and we will take care of the questions at the end of the presentation. We'll reserve somewhere between 15 to 30 minutes for Q&A. So some of the items that we're going to be covering on the presentation today, as you can see, this agenda slide. And by the way, we're going to be providing everyone who attends the presentation today with a copy of this presentation. So we're going to be circulating the slides that are a part of the presentation today after the webinar. So you can look out in your email and you're going to receive a copy of these slides. So that should answer questions. Usually during webinars, everyone's always like, can I get a copy of the slides? The answer is yes, you're going to get a copy of the slides after the completion of the webinar. So what we're going to be covering during the presentation today is how buyers really price businesses, where the legal risk is that impacts your valuation, and aligning your exit strategy with legal readiness, and then going over just a brief founder exit checklist, and then we'll conclude with a Q&A. Next slide, please. Awesome. So Nick, please do take it from here.
Yeah, so the first thing we're going to do is discuss business valuation. So something to think about when we talk about valuations at Flippa, most of the businesses that we're going to be discussing today are our core part of the market, if you will. It's owner-operated online businesses, typically in the 6 to 7 figure range. So it's important to understand, if we put our hat on, our buyer hat on, and pretended we were a buyer, how a buyer would underwrite a deal like this. So plainly speaking, buyers are valuing businesses in this price range based upon how similar businesses are selling. So it's a market-based valuation. So the first thing that a buyer is going to do when they see your Flippa listing is they're going to take a look at the trailing 12 months P&L. And the first thing they're going to try to find out is if they were running that business over the trailing 12 months, how much would they have made? What is their true owner's benefit? And the term that's commonly used in the space is seller's discretionary earnings. Now, I know this can be somewhat confusing because everything in product at Flippa is derived around profit. How I would think about seller's discretionary earnings is that profit number plus any add backs like discretionary expenses or personal expenses that are on the business account. That is the number, the seller's discretionary earnings number, that buyers utilize to put together the valuation for your business. So how they come to this number is first utilizing the trailing 12 months P&L that they have available, and the expectation, if you're going to start the sales process, if you are a business greater than 3 years old, that you will have at least a P&L for 3 years with corresponding tax returns for those years and yearly balance sheets as well. Now, I'm sure some of you are thinking, if you are building a business with the exit in mind and your business is going to be worth somewhere in the low 7 figures, how many buyers are there out there that can actually write me a check for a $2 million business? And the answer is it's not that many. So the thing that will help broaden your pool of available buyers, and this is a term we'll hear from buyers quite often, is how bankable your business is. So what this means is, can a buyer go to an SBA lender or go to their local bank and get a conventional loan for your business? And that's where it's really important to understand the mechanics of your historical financials. And some of the pitfalls as you're building your business, things that you should be aware of, is that first, most of these lenders are lending based upon the tax returns, not the P&Ls that we're advertising on the listing. And there's almost some sort of an inverse incentive, if you will. And we find this a lot with owner-operator led businesses, where each year during tax season, you're trying to minimize the amount of income that you're showing the IRS. And in the US, at least, you're very much incentivized to do that. The challenge is, when it comes time to selling your business, you're doing the opposite. You're trying to maximize the amount of profit that you're showing for your business. So because of that, if there is a very big disparity between the profit shown on your tax returns and that on the P&Ls that we're advertising on the listing, your business will not be bankable. So if you're 2 to 3 years out of selling your business, start to have those conversations with your CPA to ensure that you're doing what you can within your control to broaden the pool of available buyers that you have. Now, this isn't all about financials. It's a big driver, but so is operational documentation as well. What acquisition entrepreneurs want to see is, can the current owner be replaced? Do they have standard operating procedures so I can step in, take the keys on day one, and sustain what they have built? So once a buyer finds that seller's discretionary earnings number, and it's very common for them, the first thing they do, ask for a trailing 12 months P&L on Excel to find out, hey, if we add back certain expenses that maybe aren't necessary to running the business, then what they do once they have that SDE number is apply a multiple that typically is within a range that's dependent on business type. And that's how they get your offer. Okay. So it's important to understand the different multiple ranges depending on your business type. Whereas, let's say a SaaS business in most cases is selling between a 3 to 4 times trailing 12 months SDE. An e-commerce business, depending on what's going on in the market, may only be selling for 1.5 to 3 times trailing 12 months SDE. And if you're trying to get more insight, somewhat of an aside here, and you're just somebody that's really fascinated by the space and you want to get a sense of like the aggregate data, what is that telling us? I would go to our website, go to our insights tab, and that is where we pull together all the deals that we do to give you a sense of where the market is for your business, depending on what you're selling. Now, obviously, that's a big range that I just outlined for some of these different sectors. So, and to put some numbers behind this, back of napkin math without a calculator, if we're looking at an e-commerce business that's doing 100K in SDE, that means that the range, depending on some of these other factors here that it could sell for, is anywhere between $150,000 and $300,000. It's a very big delta, right? So some of the things that I'm going to discuss with you right here are things to start thinking about that would get you on either the higher end of the range or the lower end of the range. The first thing is transferability. If you're a business owner that is building your personal brand that is very much intertwined with that of the business, and it becomes very difficult to take you out of the business, your business isn't very transferable. That will hurt the multiple that a buyer applies to your purchase price. Documentation, any gaps in documentation are a big red flag in this space. So you want to make sure you have the financials that we had discussed, as well as the operational documentation to ensure of a clean transfer. The next piece here is risks. And this is very different depending on the business type, right? So if you have 90% of your goods being produced by a single supplier as an e-commerce business owner, that's going to be a risk for a potential buyer that they're going to take into consideration when building your offer. Another risk is going to be if you're building a software business and you have 3 customers that represent 70% of your monthly revenue. That is going to be a risk to a potential buyer. But another factor, if you have a sales background, any of you are sales or marketers, being able to share the vision of what your business could be with a potential buyer goes a long way in getting a higher multiple and ultimately a higher purchase price. And then ultimately with growth levers, it's not all about the revenue, it's about the revenue quality. Do you have multiple income streams? Do you have any recurring revenue? These are things that buyers value more. And then as it relates to defensibility, how strong is your brand? How difficult would it be for a competitor to come in and take market share from you? How strong is your IP, trademarks, patents? These are things buyers take into consideration. And the last piece, and something that's very important, is buyers don't want to just sustain what you've built. What buyers want to do is have enough margin to either invest in marketing and grow the business, or if you're running a software business, be able to invest in adding developers. If you're running an e-commerce business, be able to invest in product design and grow your product suite. These are all things that will help drive up the multiple and ultimately help make you more money. And as a similar aside here, the deal structure you get is also somewhat correlated with the risks and opportunities that I just discussed that dictate the multiple that you receive for your business. So it's really important to understand, I think, as we get started with this process and you get started with us at Flippa, first, understanding the deal structures that you can expect, and then also understand the things that could drive a buyer in a certain direction as it relates to putting forward a deal structure in front of you. So just to stay on that one point as it relates to risk and valuation, like I had said, most of the deals that we're seeing at Flippa are not all cash offers. Typically, I would say a good, strong offer in this market is anywhere from 50 to 75% cash down at closing. And because of the difficulties of financing an online business, which is a little bit more difficult because most lenders love to have an asset that they can touch and feel that's tangible. So because of that, there is a lot more seller financing in the space. There are a lot of performance-based earnouts that we see. And depending on some of the factors that we had discussed that influence the multiple, those also influence the deal structure as well. So can you get 100% all cash at closing offer? 100%. But you want to make sure you have your documentation in order. Make sure that the business is actually transferable. And if you foresee any of the potential challenges that I had just discussed, make sure you're doing what you can now before you start the sales process to get out ahead of those. So some other, sorry, if you could just go back, just one last piece. Something that does come up often is how do we bridge the gap without touching the financials? And the one thing I would say that I've seen sellers do effectively to get more cash at closing and get the price that they're looking for is longer post-sale support. And we see this quite often with a business where a buyer is worried about maybe core customer risk or key supplier risk, or that the business won't transfer seamlessly. So if you are a seller that would be able, even in an advisory role, to stay on board for 6 to 12 months, that'll greatly increase the likelihood that you get the deal structure or the purchase price that you're ultimately looking for. So just the last piece here as it relates to valuation. I know I'm probably speaking to a lot of entrepreneurs here, and it's important to understand that the mindset that it takes to be very successful at building a business from 0 to 1 is somewhat of a a different mindset than what acquisition entrepreneurs are looking for when they're buying a business. See, acquisition entrepreneurs, they're looking for predictability. They're looking for process. The first thing that I talked about, documentation. They want to see financial documentation. They want to see standard operating procedures. They want a path that they can follow to become successful. So those are a few things to keep in mind as you're continuing to build your business with the exit in mind and some of the core drivers of what goes into valuation. And then I'll turn it over to Omid here.
Thanks, Nick. Appreciate it. So when we're talking about getting the most money from the sale of your business, it's actually super important that we address legal risk, because you can build all of those aspects into driving the value of your business that Nick talked about. For example, you can have, a business that demands a significant multiple because it's in the SaaS space and there's subscription revenue, for example. But every deal that I've done, and I've done well over $1 billion worth of deals. And in every deal that I've done, I've always seen some sort of structure to the deal. And when I say structure, what I mean is, as Nick mentioned, most deals are not done cash upfront. They're usually a mix of different structures. So in my presentation, I'm going to talk about how legal risk shows up and how it impacts the price. And my goal is, when you walk away from this webinar, for you to understand and actually have action steps that you can go assess your own business of where that risk might show up. And just quickly, some of the silent valuation killers that you might find are, the common legal red flags that they're going to find in diligence, IP ownership, contracts, employment, and compliance gaps. And I'm specifically going to talk about how legal uncertainty leads to chipping of the price, as in lowering the price, escrow holdbacks, again, lowering the cash that you get at close. Because oftentimes the purchase price that you start with isn't what you're actually going to make when the deal closes. And I'll talk a little bit about that more as the presentation goes along. Longer indemnity periods. Anytime a seller comes to me and wants to work together, they're always like, how can I keep the money? How can I make sure that the buyer isn't going to come after me after this sale closes? And the way that you do that is by limiting the indemnity period. And the worst of all scenarios, the one that really breaks my heart to see anytime it happens, is deal abandonment, where the buyer just walks away from the deal because the risk is too much. And I'm going to talk a little bit about why founders often underestimate these risks. Next slide, please. Awesome. So before we talk about anything, let's actually zoom out a little bit and understand the acquisition process. What are the steps that every acquisition deal goes through? And the M&A process is as follows. First, you list your business on Flippa. And as you list your business on Flippa, there might be, some documentation that you're going to need to provide, for example, 3 years of financials, or there's going to be some sort of a SIM that's put together about your business. And that SIM talks about, what your revenue is, what your profit is, what your growth rate is, what your retention rate is, essentially the metrics related to your business. And the buyer is going to look for those things in the pre-diligence phase. Pre-diligence is buyer wants to know, what is your business about? How does your business work? How much money does your business make? That is the information that they're going to look for them to initially put the LOI. And a lot of these documents, by the way, are actually built into the Flippa platform. I believe they have a template LOI, and I believe they have a template purchase agreement. So, but it's important to work with a lawyer to amend these things to make them specific to your deal. So going back to the steps of the process, pre-diligence, the buyer's going to want a little bit of information. It can take anywhere from a few weeks to a month. That process of the buyer and the seller essentially getting to know each other. Buyer is collecting information for them to actually make an offer on your business. When they're ready to make an offer on your business, they'll submit an offer in writing through an LOI, which stands for letter of intent. Once the letter of intent is submitted, the buyer and the seller will negotiate the LOI, and the LOI will have things like purchase price. How is the purchase price going to be paid? What are the terms of how the purchase price is going to be paid? Usually there's 10 to 20% held back in escrow, for example, through a seller note. Seller note is essentially a loan that the seller is making to the buyer that the buyer has to pay over time, usually 18 to 36 months, with an interest rate, 9, 10%, for example. So these are the terms that are going to be in an LOI. And once the LOI is signed, then the buyer goes into due diligence, where oftentimes what buyers are supposed to do and what happens in larger deals and how it goes is a due diligence request list, which is a document that usually is, it can be anywhere from 4 pages to 50 pages, but it'll have a list of questions essentially asking the seller to fill out this document that has questions about the business. And that usually is attached to the purchase price as an exhibit. And it becomes a part of the legal record to show, like, hey, here's what the seller represented about their business in response to this due diligence request list. At the same time, as the buyer and the seller are going through the formal due diligence process, where a data room is set up and you respond to all of the buyer's due diligence questions, the buyer will be responsible for getting you the purchase agreement. And that usually happens, anywhere a week to 2 weeks. Sometimes it can happen, later into the deal. In this case, as I mentioned, Flippa has their own version of a purchase agreement that's available. Oftentimes what I've seen is, buyers will make their own edits. Buyers are responsible for the first version of the purchase agreement. Then signing and closing. So it goes pre-diligence, LOI, due diligence, purchase agreement, signing and closing. Thank you. Next slide. Awesome. And remember, everyone, if you have any questions, please do drop them into the chat as they come up, and we will address any of those questions at the end of the presentation. But as they come up, feel free to drop them into the chat, and I look forward to going over those questions. And now I'm going to talk about why it's important for you as the seller to consider risks to the buyer. And I want you to put yourself into the buyer's shoes here for a second. If you're buying a business, the buyer's job is to assess and price the risk because they want to make their money back. They want a return on investment. That's why they look at SDE, because SDE tells them what their ROI on the business is going to be. So they're going to be looking for the risks, and the risks appear during due diligence. That is when I often tell, whether I represent the seller or the buyer is going to find the skeletons in the closet. Not everyone runs a perfect business. No one runs a perfect business. And so there are going to be things that the buyer finds that concern them. Actually, the very nature of an M&A deal, every M&A deal that I've ever been through is not a smooth process. It's not a linear process. It always is seller and buyer get together. Buyer gets super excited about buying the business, which, by the way, is incredibly important. Momentum is everything in a deal. Keeping the buyer's excitement for the opportunity to buy your business as a seller, very, very important. But how the process goes, seller and buyer come together. There's a lot of excitement about buying. Then they go through the due diligence process. Buyer finds things that concern them about buying the business. Seller starts to get worried that buyer is going to buy the business. And then they come together and go apart constantly until the deal closes. And then everyone can take a breath of relief and be like, whew, what a roller coaster ride. But that is how every seller describes the process of selling their business. They describe it as a roller coaster ride. So when risk shows up, what buyers do oftentimes is they lower the purchase price, they increase the amount of the seller note, they increase escrow holdbacks, they increase the cap on indemnity so they can come after you for more money. They put longer survivability periods on indemnity, which means that they can come after you for longer periods of time after the deal, or worst case scenario, they walk away from the deal. So let's talk about the 4 areas that buyers always investigate. They're going to want to look at ownership and what the state of ownership is. They're going to look at intellectual property, which is another aspect related to ownership. They're going to look at contracts and dependencies. Can the business legally transfer to the buyer? As Nick talked about, transferability, so important. And legal contracts are a big piece of that. And then they're going to look at people. Human capital is, if not it is for sure one of the most important, if not the most important aspect of a business. I describe business as a team sport. Now, we're in an age where businesses are gunning towards becoming one-person billion-dollar businesses, but we're not there yet. And so people are incredibly key to the transferability of a business. So are employees and contractors properly structured? Are there contracts? So on and so forth. Next slide. So let's talk about the first bucket that buyers are going to investigate, which is common ownership problems. So some of the common ownership problems that you'll find are, for example, founders never assigned IP to the company. So what a lot of people don't understand is that even when you own the company, let's say you incorporate an entity and you run the business for 10 years, if you never sign a contract, even as the founder with your company that says that anything that you created for the company is owned by the company, then there isn't a contract that is in place. And that's what buyers are going to look for. There needs to be an actual contract in place that gives the company the right to all of the creations that were made for the company. If there is not that contract in place, that company does not own those creations. So common ownership problems, founders never signed an IP assignment. So the company doesn't own the assets that the founder themselves created. Another common ownership problem is maybe there were 2 co-founders. One co-founder owned 50% of the business. Maybe they left on good terms. Maybe they left on bad terms. Whatever terms they left on, if there isn't a contract in place that says that the ownership that this person had in the company is being repurchased by the company, that person still owns an interest in the business. And that's going to be a concern to the buyer because the buyer wants to make sure, hey, anyone who has authority in this transaction, who needs to sign off on this transaction, needs to it needs to be papered, it needs to be recorded. And so if a co-founder is left, but they never sold their equity back to the company, or there's never a contract in place that that person who left sold their equity back to the company, that's going to be a problem for a buyer. As I mentioned, IP assignments, so important. I can't tell you how often this comes up. And everyone that has ever worked for the company needs to sign an IP assignment. So contractors, employees, suppliers, vendors, all of these individuals, entities, I often say, even if your girlfriend gives you an idea or your boyfriend, if they give you an idea and you incorporate it into your business, they should sign an IP assignment as well. And sometimes IP assignments are insufficient. They're not robust enough. Maybe it's just 2 lines in a contract, but there really needs to be a standalone IP assignment that's incredibly robust. And I'll talk about that on the next slide here in a second as well. But other common ownership problems, for example, the assets of the business, again, are not fully owned by the founder. So for example, Google AdSense is owned by the founder personally, but that founder has multiple accounts under their personal Google AdSense account. And then it turns out that that person can't parse, they can't separate that account that is being bought from the rest of their personal account, essentially. Transfer a Stripe account always comes up as a concern in terms of post-merger integration. And so making sure that that is handled as well and clean. So again, not having multiple businesses, tied to a Stripe account, for example, having a Stripe account for each one of your businesses, just making it as transferable as possible, not thinking about these things when you're in the middle of a deal and it causes issues. So how this can impact deals is buyers might ask for more protection in the form of indemnity. If you don't know what indemnity is, it essentially is a clause in a contract that says, I'm the buyer, I'm buying your business. If anything comes up that damages me, or if I get any sort of loss, then I'm going to come after you as the seller based on the money that I paid you, and I'm going to ask for that money back. And you're going to have to either defend me in a lawsuit, or you're going to have to pay me back for the loss that I incurred. Another way this impacts deals is deals get stuck in diligence. So a deal that was supposed to close 3 weeks ago is continuing because you have to fix a lot of these issues. Or if the issue can't be fixed, but the buyer still wants to buy your business, what they'll do is they'll increase the holdback. Instead of 20%, it'll become 30%. Instead of 10%, it'll become 25%. So the amount of cash that you get at the closing is less. Thank you, Isa. Now, we just talked about common ownership problems. Now let's talk about intellectual property gaps. As I mentioned, IP and ownership are closely aligned, but some IP gaps that, for example, I'm in the technology space. I deal with a lot of digital businesses, especially software. I'm actually a 2-time software founder myself. And so I work with software businesses quite extensively. And in the software space, code, for example, so, before vibe coding became a thing, which is a whole thing in and of itself, but before vibe coding was a thing, people would go hire software development agencies, or they would hire freelance developers off of Upwork or any of these other platforms. And that code written by the contractor could sometimes is a handshake deal. You find some cheap developer, 25, 35, 50 bucks an hour, and they come and they build you a software, but there's no contract in place. Or maybe you think, hey, this, developer is in this country outside of where I live, wherever it is in Asia or whatever. And you think, oh, maybe this contract won't really be protectable anyway. So why do I need a contract? Well, the reason why you need a contract is everything needs to be papered. And specifically, acquirers are going to look, they're going to do diligence on your business. They're going to say, okay, there's this developer. How long has this developer worked for you? Give me a list of all the developers that have worked for you. Okay, there's 4 developers that have worked for you. Only 2 of them are at your business right now. What happened to the other 2? They were freelancers. Okay, where's the contract for those 2 developers that were freelancers? If there isn't a contract, that's going to be a problem for a buyer. The buyer's then going to ask you 10 more questions. Well, what did that person build? Where are they? Can you get a hold of them? They're going to look for IP assignments from those contractors. And so a big intellectual property gap, if you're not getting it, like from me repeating myself, I'm going to repeat myself again. IP assignments from anyone that works for the business needs to be obtained. And this holds up deals. I can't tell you how many deals I've seen get held up by this specific thing. Beyond that, trademarks filed for the brand or the logo, the name or the logo. So if you're they're saying now that we're in the age of brand. Brand is so important. That brand, oftentimes brand distribution and audience are the moat, especially in the software space, where the barrier to entry is getting lowered with things like vibe coding. So as you build your audience and distribution and you establish your brand in the space, you need to protect your brand. You need to own your brand. The whole reason why the acquirer might be acquiring you, for example, in the case of OpenClaw or Maltbook that just got acquired by OpenAI and Facebook, those are really strong brands. Those acquirers are acquiring them because of their ability to not only get massive distribution in a short amount of time, but because they've established themselves in a space, and you need to have ownership of your brand because that's an asset that the acquirer might be interested in. And I'm going to talk about a few case studies here later, but just remember, trademarks, super important. File for trademarks for your brand name or your logo. Other intellectual property gaps are things like cease and desist letters. Let's say you didn't file for a trademark for your name and you used some name, and then you got a cease and desist letter from one of the big corporations, for example. That is going to raise red flags for the buyer. Domains not owned by the company. Domains owned personally, domains owned by some random individual who may have worked for you a couple years ago, and now you don't have access to that domain, for example. You need to track all of your assets. Where are they? Clean them up, put them in order. Open source software. So this is another thing that's really big in the software space is so open source software has licenses. You need to make sure and work with your software developers to understand where they're sourcing their code from. That open source software is going to have a license. And if it is a non-commercial license, that's going to cause a problem. If you're selling a software business, an acquirer is going to conduct technical due diligence on your business. And as they conduct technical due diligence, they're going to look for documentation and they're going to look for open source software. Those are the two big things that they're going to look for, because they want to make sure that the software is transferable, it's maintainable, it's clean, it's lean. And they're also going to make sure that they're not going to get themselves into hot water for violating any of the licenses related to that software. The other thing is, entrepreneurs can often be quite scrappy. And so sometimes, especially back in the day, funnel hacking used to be a thing, for example. Sometimes you'll find people just completely pull the copy off your website, and jack the copy from your website. So if you're doing that, make sure that you don't do that. Make sure you clean that up. And so that you have clear ownership of your marketing assets. And further to the marketing assets, again, IP assignments. That also speaks to IP assignments. If you hire some sort of a marketer, if they're creating, social media posts for you, if they're writing, LinkedIn copy for you, for example, all of these are assets that need to be owned by the company, and there needs to be an IP assignment for all of these items. So let's say that these items are missing. How does this impact deals? Again, the primary tools that the buyer is going to use, bigger holdback. That means less money for you at closing. A holdback is essentially, hey, I was going to pay you $1 million cash at close. Now I'm only going to pay you $750,000. I'm going to take $250,000 and I'm going to put it in a bank account that you can't touch for the next 18 months until I know that all of the liabilities that I discovered during due diligence aren't going to become a problem. And if they do, I'm going to take it out of the money in the bank account and I'm going to keep it, and you're going to see less money. So that's one way that they might protect themselves. Another is warranties from the seller. They're going to ask you to make promises. Hey, there was this cease and desist letter, but you represent and warrant that outside of that cease and desist letter, there's been no other issues around the brand, for example. Or they're going to make you make promises that all this code is actually owned by the company, or all of the software licenses are commercial use. So we have authorization to use the software despite the fact that they're open source code. And lastly, outright price reduction. I was going to pay you $1 million. I'm actually not even going to put it into escrow. I'm going to reduce the purchase price by $250,000. That's what you don't want to happen, and you can prevent it from happening by making sure that you address all of these points. Okay, contract risk. So contracts, super important. Not having written contracts or informal or verbal contracts, no written agreements with your key vendors. The main point here is make sure that you paper everything. But even more so than that, some people think, okay, I have contracts, that's great. Well, the point that I want you to take away from this slide is contracts need to be assignable. Nick talked about how transferability is important. Contracts that are not assignable are non-transferable. Contracts that are not assignable means that the person that you have the contract with, for example, a big customer, can come back and say, hey, actually, this deal that you're doing, I'm going to cancel the contract and I'm not going to assign the contract. That's why contracts need to be assignable, so that the business can transfer and customers don't terminate their contracts as a result of a no assignment clause in a contract. So favorable contracts ensure transferability of the business. And how this impacts deals is longer closing timelines, deals get delayed, reduction of the purchase price via clawback or set off. It's the same playbook here. And actually super important, haven't talked about it yet, buyer loss of confidence. When the buyer loses confidence, your price gets a hit. Lastly, people risk. So as I mentioned, human capital, so important. Business is a team sport. Buyers are going to be looking for written contracts with your workers. So if there's no written contracts, that makes your business look messy. It shows a messy business, someone who hasn't, attended to their business, someone who hasn't taken into consideration the liabilities. It also just shows that you're not that serious about your business. So why should the buyer pay you a significant purchase price if you haven't taken your own business seriously? Misclassification of workers. In the United States, there are two types of workers. There are employees and there are independent contractors, and each one has rights and responsibilities, and it's actually super important that you do not misclassify people. If they're independent contractors, you need to follow the laws around independent contractorship, because if you misclassify them as if you misclassify an independent contractor and they're actually an employee, that risk transfers with the business. So the sale of the business will not protect the buyer from the risk of that employee coming back and suing. As I mentioned, the key asset in most acquisitions are the people that built the business. So written agreements just ensure that those people are secure and they reveal that the business has been operated in a risk-free way and in a prudent way. So where buyers find people risk, again, escrows and holdbacks, bigger indemnification, carve-outs, and personal liability.
Hey Nick, and Umid, just wanted to say that we might want to speed up on the slides a bit if we want to keep some time for the Q&A.
Awesome. Thanks. Yep. So the first case study that I'm going to quickly go over, as I mentioned, Google AdSense, there was a seller who had a number of accounts in their personal Google AdSense. They weren't able to separate that account from their personal account. And by the way, the buyer in that deal, who came to us after the deal was done, so we actually didn't even represent this buyer. He came to us after the mistake had already happened. The seller accidentally forgot to include the Google AdSense account in the list of assets, and then a huge lawsuit ensued. A lot of money had to be paid both for the lawsuit, and the seller had to pay the buyer a significant amount as well. So you want to verify that the accounts are transferable, and you also, as if you're a buyer and even if you're a seller, you want to make sure that the assets that you're selling are actually listed in the agreement. Another deal that we did, again, we represented the buyer. Buyer was buying a software business. The software business had very large enterprise contracts with customers. One of the contracts had a no assignment clause, and essentially the deal got held up. Buyer seriously questioned whether they wanted to buy the business because they couldn't get a hold of the enterprise customer in time. They were rushing, trying to get a hold of the customer, and they couldn't. And then buyer seriously questioned whether they wanted to buy the business. Ultimately, what they ended up doing was they increased the holdback, essentially contingent on the customer saying, yes, it's okay for this contract to transfer to this new buyer. So it ended up working out for the seller in that instance, but it doesn't always. That's why it's super important to make sure and do diligence on your customer contracts to make sure that they're assignable. Lastly, we just did a deal a few weeks ago, sale of a blog. Originally, they were going to sell their blog for 900K. The deal ended up coming in at right around 700, something like that. A lot of reductions that happened. The business was missing IP assignments. The business came to us. They were ready to sell in September. The deal didn't close until January because the buyer essentially said, hey, until you get IP assignments from everyone that has worked for this business and created content for this blog, I'm not touching the business. And so the seller had to go back. They had to get something like 7 IP assignments from people. Ultimately, it worked out for them. We actually helped them set it up in a way where they were able to get those IP assignments quite quickly. But that is it. You see the risk. The price dropped, and the deal very easily could have died. So with that, those are all my case studies, and I'm going to hand it back to Nick.
Yeah, and for all the e-commerce entrepreneurs out there, one of the coolest things that I see is somebody starts something out as a side hustle and it turns into a full-fledged business worth millions of dollars. But the challenge with that is you have to adjust how you do accounting as the business continues to grow and develop. Something for all of you to consider is cash versus accrual accounting. Most buyers, especially if they are writing a 7-figure check, the expectation is that you will have an accrual-based P&L as you start the sales process. And something that Omid discussed during his part of the presentation is the importance of fixing issues like this well before you start the sales process, because already we're looking at typically a 6-month sales process. And in this case, I had an entrepreneur that came to me. He had this great business that was doing roughly 500K in net profit. But he was having one of his brothers do his accounting, as he always had been. And so they were only buying inventory twice a year and doing cash basis accounting. So they were recognizing that inventory spend when that inventory was purchased. The challenge with this versus accrual is the P&L looks very lumpy, and we update financials every month. So when we started having conversations with potential buyers, most of the interest was around $1.2 to $1.5 million until that second month he was in the sales process with us. He did his biannual inventory purchase, which took trailing 12 months net profit from $500,000 to $100,000. So all of the buyers that we were talking to at the $1.2 to $1.5 million price range disappeared. And all the $1,000. So a very difficult account to have. Obviously, with the $1 million delta, the seller was not willing to sell the business at that price. So what he did was pause the sales process. And it took a lot of money and about 2 months for a new accountant to put together an accrual P&L, which allowed buyers to underwrite unit economics, how much they would actually have to spend in order to sustain the business the first 6 to 12 months in the owner's seat. So ultimately, the adjusted P&L showed a trailing 12 months SDE of closer to $350,000. So we ultimately got the $1 million offer that he was looking for. But as you can see here, just by how the information is put forward can have a drastic impact on valuation. So do this well ahead of time. And as your business grows, so do your processes. They have to improve as well. And then the last one here, we're seeing a lot of influencers get into e-commerce. As you can imagine, developing a really strong TikTok and Instagram following is a very cheap way to market to a consistent audience. So we're seeing a lot of folks. In this case, I was working with somebody last year that was really into fashion, and they developed a really strong following within a particular niche, and they built a product-based business off of this niche and off of their Instagram account. The challenge, and as we talked about transferability earlier, Omid hit on it as well. If the new owner can't come in and sustain what you've built, they are either A, going to run for the hills and not talk to you about buying your business, or B, adjust your P&L substantially to account for the increased marketing that they would need to do in order to sustain the revenue base that you've built out. Just back in napkin math here, if we were, for instance, doing $100,000 in SDE over the trailing 12 months, well, in this case, the owner would expect to get offers between, let's say, $200,000 and $300,000. But when a buyer looks at this business, what they're going to see is, hey, I have 32 Instagram followers. They have 320,000. So I'm going to need to underwrite potentially 30% of that in order to account for marketing spend to keep up that revenue number. So SDE goes from 100 to 70. Your interest goes from maybe around 200 to about $140,000. So that's a loss of $60,000. So we did have to re-underwrite the expectations that the seller had, but ultimately what you're doing, if you've built a business off of your personal following, what you are looking for here is not just somebody that will buy your business, but somebody that wants into a relationship with you to either A, help over a longer period of time, guide them to running your business, or B, use your advice to help grow their own social media following. And that's what we did here. The owner agreed to stay on for about a year and a half to be the face of the brand. And they also, as part of the sale, if the buyer were to meet the purchase price, agreed to be a consultant, a social media consultant, to help this buyer grow their social media following. So it just shows if one of those factors that we've discussed all afternoon is potentially a red flag for a buyer, you have to do some creative things in order to get the purchase price that you're looking for. Next slide, please. And obviously all of you guys will get this deck from us. I think what it comes down to at the end of the day is preparation, having documentation, and just understanding that you're going to want to do all the work ahead of time to make the sales process, which can take anywhere from 6 to 8 months, as seamless as possible. And then those are our LinkedIn's, me and Omid's. Feel free to connect with us there so that you can ask any questions that come through over the next few days or weeks. And I believe we have a few minutes here to answer any questions that you have. Aiza, how do you like to do this?
Yes, Nick, Omid, we have a few questions. Let me open them up. So the first one is from Hannah, and she's asking, is there some kind of a template to generate IP assignments?
I don't believe Flippa provides a template to generate IP assignments. But that's something that that's a service that actually we provide in my law firm. So if you want to connect with me on LinkedIn and send me a message, I'd be happy to chat with you about IP assignments.
And then Catherine's asking if for a software coder situation, like when a developer who is already midway through work, how do you ensure a robust enough IP assignment midway through? And is there any reason to rush that IP assignment before you are ready to list a business for sale? What is the advantage of doing that?
Yeah, I mean, the general approach should be at the beginning of the relationship, you obtain the IP assignment. But if I were, mid relationship with a software developer, my big question is, do you have a contract with that software developer? Sometimes people have contracts with the software developer and that contract has an IP assignment as part of it. But if you don't have a contract with that IP, with that software developer, what I would do is I would just message them and I would say, hey, by the way, I have this document. It essentially just ensures that the code that you write, I'm going to own, and essentially make it contingent on them. I don't know how you are paying them, if you're paying them weekly or milestone, but I'd make their next payment contingent on them signing that IP assignment. But it is really important to get the IP assignment at the beginning of the relationship. You should not be trying to get an IP assignment anywhere close to a sale, especially not in a sale process. The most ideal is at the beginning of the relationship, or if you are thinking about a sale, 6 to 12 months in advance of the sale, you should be cleaning these items up before you get into the sale.
Thanks, Omid. And Derek's asking if he's selling a large e-com site, is there someone he can connect at Flippa with? Derek, you can connect with Nick right here. And yeah, I think he'd be happy to walk you through the entire process.
Yeah, Derek would love to connect with you. If you could just shoot me over a note via LinkedIn, and I'll shoot you over an email and we'll schedule some time to connect.
Great. Those are all the questions so far, but I do see AJ is typing. So yeah, let's wait to hear from him.
Okay, cool. And if you haven't already, please do make sure to connect with me on LinkedIn. If you DM me on LinkedIn, I actually can provide you with a more robust founder exit readiness checklist that I'll give to everyone as a gift for joining this webinar. Yeah, please do connect with me and Nick on LinkedIn. As mentioned, you'll also be getting these slides after this webinar is over, so look out for that. And have we heard anything from AJ yet?
Yeah, and Umid, I think this one's for you. He says that he has a user-generated content social media site where the content is owned by each user, but they give a perpetual license to the site to host it. What precautions should they think of?
I think in that case, as long as your terms of service are very specific in terms of how the content is owned, and you make sure that each person has to agree to those terms of service at the time of registration. And I think it all comes down to what the terms of service for the website says, and then how people have to go through the process of agreeing to the terms of service. So I think that those would be the places to start in terms of assessing how you should be thinking about it. But based off of what you've said, in terms of if they give the company a perpetual license, it shouldn't be a problem.
Thanks, Omid. I don't see any more questions from the audience, but yes, just want to add in here for everybody else that all the LinkedIn links and everything will be added in the post follow-up email from the webinar as well. And we have another one question coming in from Philip. Let's wait.
Awesome.
Umid, this one's for you. Philip has followed you on LinkedIn, but your DM is locked. So.
Oh, okay. Okay, got it. Well, I'll accept your invitation to connect. And I think with that, Isa, if there are any more questions, please do reach out to both Nick and I on LinkedIn. And thanks so much for joining the webinar. Really appreciate it. Hope you got a lot out of the webinar. If you do send me a DM, I would love to hear from you about what you took away from the webinar. I love getting that information from people and figuring out what was most important in terms of information. But it's been a real pleasure to be here.
Yeah, thank you, everyone. Appreciate your time this afternoon.
Awesome.
Thank you.
Take care.